welcome to the People's Lawyer channel. Today we're looking at combating medical tyranny, and in particular with regard to taking a test, a COVID test. So we're on part 4A of the series. And before I go through the materials, which is essentially a letter of conditional acceptance, which is similar to the one that we did for defending against a vaccine requirement, I'd just like to ask a few questions. This is not medical advice. I'm not suggesting that people do or think anything in particular, but I am asking them to ask themselves certain key fundamental questions, the same questions that I've asked myself when I do my own research. The first question is, are we satisfied that germ theory was ever established over terrain theory? So I would ask you to have a look in the research and see what you come up with. According to germ theory, we can transmit infections to each other, but that was never proven as far as I'm aware. And according to terrain theory, we don't get infections as such from other people. We just get toxic and we get diseased from toxins. And when the body is removing them, they're removed in such a way that it looks as though we've fallen ill with something that we can spread to someone else. That terrain theory suggests that it doesn't work that way. So please do your own research. Another question is, has the alleged virus ever been isolated? Well, you could even take it further than this. You could even ask, has any virus ever been isolated? There's a massive debate going on at the moment about the nature of viruses. But the question, there's a doctor called Dr. Robert Young who has offered, I think it's $5 million for anyone that can prove the existence of any particular virus, let alone this COVID-19 virus. So that's another important question to ask yourself. Another question is there a reliable test for it? Can there be a reliable test for a virus that has not been proven to exist? The creator of the PCR test, Kary Mullis, who died about 2 years ago, suggested that his own test was not a diagnostic tool. And the way it's being used would suggest that it's not reliable at all. Again, this is not medical advice, but is there a reliable test is the question that I'm asking you to ask yourselves. And the final question is taking a test not a medical intervention that requires fully informed consent? So do we not need to know what's in the swab test? What are they putting at the end of the swab? Do we not need to know where the DNA that they are collecting, do we not need to know what they're doing with it? Is this not but an absolute massive breach of GDPR, privacy laws? Because this is our data, this is information relating to our data. So these are questions that we need to ask ourselves. So without further ado, I'm going to move on to the material, which is again a letter of conditional acceptance. You will find the body of the text in the description box on YouTube. You'll also find it on the Telegram channel, People's Lawyer public Telegram channel, and on a website that's soon to go live, which is all the w's.thepeopleslawyeruk.com. So here we go, letter of conditional acceptance. And remember, just to reiterate, when you refuse anything, you're being dishonorable. So refusal is not a good idea. Acceptance is the way to go at law. It keeps you in honor and it keeps the wolf at bay. And as I said in the previous installment, it reverses the burden of proof. If you refuse anything, then people can legitimately ask you to justify your refusal. Well, you may be able to do that, but that's stressful and unnecessarily complicated. It's far easier to reverse the process, put the ball back in their court and say, happy to comply, but you must prove the following before I do comply or before I do consent. Okay, so the first line is, I will agree to comply with your requirement to submit to a SARS-CoV-2 swab on strict condition that A, you answer in the affirmative each and every one of the questions below, and B, you are prepared upon unlimited personal liability in your private capacity to accept responsibility to indemnify me or my estate for an amount not exceeding £1 million for any financial loss, psychological or physical harm caused to me as a result of submitting to such a test in honest reliance upon your affirmative answers to said questions. Question 1. Has SARS-CoV-2 ever been isolated from an infected person and examined under clinical laboratory conditions? Question 2. Has SARS-CoV-2 met Koch's postulates? For those who are new to that concept, according to Koch's postulate, a virus has to be isolated, cultivated, transmitted, and cause disease or infection in an otherwise healthy person. So has it met Koch's postulates, which without passing that test, then it doesn't count as anything. It's a non-medical issue, which established it as responsible for the disease named COVID-19, therefore posing a serious public health hazard. Question 3, were the World Health Organization, the US Center for Disease Control and Public Health England, all mistaken when they downgraded COVID-19 to an infectious disease of non-high consequence on March the 19th, 2020, as posted on their respective websites? If you look around, you will see evidence, because some of us took snapshots or screenshots, screen caps. So we have the evidence that on the March the 19th, whatever SARS-CoV-2 or COVID-19 was and is, it certainly was downgraded to the status of, in effect, the common cold or a mild flu. And that is fact. That's not any kind of theory. That is what actually happened. But you won't read about that on the BBC or the mainstream media. Question 4, is the SARS-CoV-2 swab proven to be a safe procedure or even necessary when saliva from the oral cavity would produce equally reliable data regarding infection status? Question 5, is the SARS-CoV-2 swab sampling via invasive nasal insertion considered to be a medical procedure, and as such comes within the ambit of the Universal Declaration of Bioethics and Human Rights, 2005, or UDBHR to shorten it, therefore requiring fully informed consent pursuant to Article 6 of said declaration? Question 6, do you agree that SARS-CoV-2 swabbing is a medical intervention which I am free to refuse according to Nuremberg principles without disadvantage? Question 7, is the SARS-CoV-2 RT-PCR test 100% reliable so as to avoid false positive and false negative results in statistically significant numbers? Question 8, was the inventor of said RT-PCR test, Dr. Carrie Mullis, deceased 2019, mistaken when he said that this test is not designed for or meant to be used as a diagnostic tool? Question 9, are you satisfied beyond reasonable doubt that refusing access to services against a person who does not agree to the SARS-CoV-2 RT-PCR test is not an act of discrimination pursuant to equality and disability legislation, or an act of socioeconomic and moral repression against natural common law principles of sovereignty in living men and women? Question 10, are you satisfied beyond reasonable doubt that any consequences for failing to agree to be swabbed for SARS-CoV-2 shall not constitute infringement of my rights pursuant European Convention on Human Rights and or the Human Rights Act 1998, or my rights to privacy pursuant General Data Protection Regulation? So that's a hint of the data that is being processed in these swab tests. It requires, under GDPR, your explicit consent. So that's another avenue to pursue. Question 11, are you prepared to set out your precise reasons upon independent evidence for your affirmative answers? So to questions 1, 2, 3, 4, 7, and 8. And question 12, which is the GDPR criminal notice, basically criminal offence notice. Do you understand that concealment of data and blocking or willful refusal to provide data or information relating to our personal data is a criminal offence pursuant Data Protection Act 2018, Section 173. I won't go through the final paragraph because it's the same, pretty much the same as in the last installment, which was the Section 3A or Part 3A and B for vaccines. But what I will say is I will reiterate that this is a powerful tool. Conditional acceptance is how you remain in honor, is how you remain in your integrity and in your power. You're basically asking questions to which you know the answer. That's the key. That's why it's so important to do your research. So watching these videos is a wonderful first step to becoming empowered. This is the lawful legal side of it. Well, lawful particularly. But you need to comprehend that there is some that there are some serious health issues and health concepts, medical health concepts here at stake, and that the mainstream is giving us a slanted picture of reality, a very warped view of truth, and we need to countermand that with common sense. So the antidote to tyranny, in one word, or one phrase, I should say, is common sense. Common sense will make you do the research, and common sense will make you use these tools that I'm putting online to your best advantage for the best possible outcomes for the highest number of people. In the next episode, we will be looking at, well, it will be part 4B. We'll be looking at the traveling implications of being asked to go into quarantine, where as a precondition for travel. By the time you watch this, hopefully it will have been abolished. But just as a safety precaution, we'll do some research and find some key empowered solutions to help you avoid the indignity of false imprisonment, of unlawful imprisonment, basically. So we hope that's been of great value to you, and we'll see you sometime soon. And remember to keep your eyes open for the new website and to go on Telegram channel, the People's Law Public channel, where you'll find more helpful videos and resources. Thank you very much, and we'll see you soon.